There are times where individuals participate in in-person pitching to investors, pitching their ideals and dreams to be placed in stores, or they submit their script to pitching competitions. And they believe that sharing this information to hopefully get an opportunity, that their ideas are protected. There are plenty of times I've heard people say, well, I know my ideal is protected because I've even put on my material that this IP can't be reproduced. So they put it on the material that's already submitted. Or if they're doing an in-person pitch, they put on a material and people are reading this as they are doing the pitch. Well, saying that this IP can't be reproduced either verbally or written on your material that you submit or you put in front of individuals does not protect what you are disclosing. Not by itself. There's so many other things that need to be done in order for a person to get full protection of what they're sharing to individuals, especially if it's an ideal. Otherwise, someone saying it or putting it down on paper, it just tells the room what you are afraid of losing. Real protection comes from law and from agreements. And neither one of these things starts with something you say in the moment or share without establishing acknowledgement of your expectation. What do you mean, Alakisha? Well, okay, copyright, trade secrets, trademarks, and possibly patents. All of these protections can come into play when something is being pitched. It will fall into one or all of these categories. And if what is being pitched is just an ideal, then a warning phrase triggers legal protection for none of them. Copyright, for instance, protects the written expression, the unique written expression of work, not an ideal. Copyright doesn't protect an ideal. There are so many times that people come to me and say, what can I do about this? Someone stole my ideal, either through pitch submission or pitch delivery. Someone stole my ideal. Well, if what was stolen is something that is would have normally fall under copyrightable work, then it's not protected if it was just an ideal. You have to take it from ideal to the next level. This is why people love to hear ideas. They'll say, tell me your ideal. Tell me your ideal. Before you share ideals, there are things you need to do. Even though an ideal cannot be protected via copyright, there are other ways ideals can be protected contractually, if done right. It just can't be protected federally through copyright. And if it's not memorialized or copyrightable, it will not be protected no matter how much the person pitching phrases the warning. And if it's not already federally protected, put down from ideal to something memorialized and federally registered, then that's a whole other level of benefits loss and protections that are made complicated. When we look at trade secrets, which trade secrets shouldn't be shared in pitches, but some people don't even realize the type of protection certain creations fall under, especially when it comes to trade secret. But in order for a trade secret to be enforceable, to protect the information, the person that's receiving the trade secret must accept a duty to keep it confidential before disclosure even happens. There are different ways to accomplish this, but if you are sharing information to someone who has not affirmed such obligation, it loses its protection the moment that it is shared. When we're looking at trademarks, which protects branding, the source identifier, an identifier of a source where products and services come from, name, logo, slogan. This is not protected unless it's already in use. So you can have common law rights, but there are limitations to common law rights if it's registered or pending registration. An unregistered or unused source identifier that's dropped into a pitch is exposed. So when someone loves that trademark that you have and the right things are not in place and they're the first to use, there can be a problem there. So knowing the what, the how, and the why certain protections actually work is what helps a person prepare for the pitches beyond the presentation. If you walk into a pitch or submit to a pitch competition online with nothing registered or signed contractually, you're playing crapshoot with your name, your branding, your concept, your vision, your dreams. You could book a legal strategy meeting to talk deeply via Zoom or phone about the protection you need to build before sharing your vision publicly. The strategy that actually protects your pitch gets built in the legal strategy meeting, and we can do that together. However, if you already know what you need, but you want to know how you can secure ongoing trusted protection, you can book the complimentary 15-minute inquiry call. Until then, I want you to keep learning with the Ownership Attorney.